All right, and so Jim and I have been hearing you say all day today pretty much that it's going to possibly get warmer.
Yeah, we're definitely going to see some warmer conditions starting off tomorrow. We've had a little bit of a break from the heat this weekend with the lower 90s instead of the upper 90s, but those will be back eventually. Tomorrow we're going to see those temperatures around 95, 96 degrees in the afternoon with isolated thunderstorms. So you'll definitely want to have your umbrella handy for the next couple of days. But by Wednesday and Thursday, we're going to see nice dry conditions. We're expecting a lot of sunshine for the end of our next week, but we are also going to see a warming trend around that time. Temperatures briefly dipping into the upper 80s, but then back into those mid to upper 90s by the weekend, and next week looking even hotter for now.
Yeah, hearing you say that, all I heard was that, Rob, you need to stay indoors all next week.
Hey, that's what I do as well.
All right, Anae. Thanks, Anae. Thanks, Jim. WAAY 31 gives you 24/7 coverage. You can count on local news, breaking news, and severe weather. LawCall is next.
This is WAAY 31 Law Call.
Good evening and welcome to WAAY 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions all about injuries, particularly summertime injuries. Kids are out of school, they're out and active, vacationers are on the road, a lot of people traveling and in places they're not accustomed to being, more boats on the water. You just see a different kind of injury in the summertime, so we're taking your calls and questions on any kind of injuries, but especially summertime injuries. You can call in the 31 Law Call number 256-536-0077. You can call, but here's something new. You can also text to that same number. If you're a little shy of going on the air, you can text in your question. We'll have those questions tonight as well. You can also email your questions. You can email any kind of legal question any day of the week. You send it to lawcall@waytv.com, and when we get to a show that's on point, we'll pull some out. We will have some of your email questions with us tonight. Heath Brooks is here from Timberlake League and Brooks. Good to have you here.
Good to be here on a hot night.
On a hot night, going to be hotter. Summertime injuries, you guys do personal injury cases.
Right.
So that's a wide variety of things, including medical malpractice, car accidents. Summertime gives you a whole new crop of problems.
That's right. I mean, you know, everybody's hot. They want to get out. They want to see what's going on. You know, you got boating accidents, you got pool accidents, you got people on vacation that get hurt in faraway places. It's a whole different, you know, every season of the year brings on different kinds of situations and different kinds of injuries. But summertime injuries certainly can be very, very bad.
So if you've got questions, call in or text in. Maybe you got frustrated with neighbors and fireworks.
Yeah.
Maybe something got set on fire. Call in or text us and let us know. And getting us started tonight, we've got something we like to pull out a video, and you make the law call. So this is an actual some video from a couple of years ago that saw national attention. You know, folks shooting off fireworks in the neighborhood, and watch what goes wrong. Fortunately, nobody was injured. Well, the vehicle over there is about to get injured.
Whoa.
When you look at something like this, what are you thinking about from a liability standpoint? So thank goodness nobody got injured. But from a liability standpoint, are you looking at who bought the fireworks? Are you looking at who lit the first fuse? Are you looking at who's hosting the event? What are you thinking when you're thinking responsibility?
First thing I think about is a family reunion I had on Weiss Lake years and years ago. And the same thing happened, and we dived behind trees and jumped in the lake. But the thing about it is, fireworks are dangerous.
Yes, they are.
They are dangerous. And when somebody is negligent in setting them off, they can be responsible.
Yeah.
It's not necessarily who actually owns the fireworks,
Okay.
who provided the fireworks, unless there's a minor that is setting off the fireworks. And that's
Okay.
one thing in the state of Alabama. If you are going to purchase fireworks or you're going to set them off and you are under the age of 18 years old,
Okay.
in Alabama is the rule, then you have to have an adult supervising you when you're setting those fireworks off. Doesn't look like that's the case there. And the other thing about fireworks is that as adults, we have this concept called assumption of the risk. We all know that fireworks are dangerous. So if somebody sets off a firework and it goes bad and it hits you and you're injured, then a lot of times the law says you may have assumed the risk. The difference is that, let's say somebody sets off a bottle rocket and throws it at you. Well, that's a different ball game. If you're injured there, you may have a claim against the person that set off the firework. You may have a claim against the person who allowed their young child to set off fireworks. There are some situations where someone can negligently or even recklessly set fireworks off and cause an injury, and you may have a claim. that gets a homeowner's insurance policy potentially.
Call in your questions, 31 Law Call number 256-536-0077. You can also text us questions to that same number, 256-536-0077. Okay, we got this email question from Benjamin. Benjamin says, is there a general rule on who pays when there's a serious injury at a pool party, especially where alcohol was being served? Okay, talk to us about pool parties and things that you're actually inviting people to. Now, I know if somebody gets hurt wandering over on your property that was not invited to be there, it might be a different rule, but pool parties.
So you're at a pool party, it's the same sort of deal when you're dealing with a minor. If you're at a pool party and there's an adult there and that adult is serving minors alcohol, and a minor goes out on the road and is drunk and causes a wreck and God forbid causes an accident, then that individual who served that minor alcohol could be responsible. If you have a party where you are serving to visibly intoxicated individuals, then there could be a situation where you're responsible if you allow those, if you continue to specifically give those folks alcohol. So there are situations where you're at a pool party and you're continuing, you own the house, you're providing the alcohol, and you're continuing to allow people to get drunker and drunker and drunker, then God forbid they get on the road and cause a wreck. And there could be some responsibility there.
Okay. We got in a text question, so someone has just written in. My question is, if you are disabled and you fall on and break bones on somebody else's property, can you file a claim because you were injured on their property? Okay, kind of a little confusing as to whether they were already disabled or if they just become injured on somebody's property. If you get hurt on somebody else's property, what can you do about that?
There's a couple of different things you got to deal with there. First off is, are you on a residential property? Are you on somebody's private property and you're there just to visit? And if you're on somebody's property and you're there just to visit them as a friend or not providing them any kind of business or material benefit, then likely if you get injured on their property, you're not going to be able to have a claim against that private homeowner. The difference would be if there is some sort of defect on the property, like a well that was covered over that they knew about, you didn't know about, and you fell in, there could be some responsibility there. The difference is, though, is that if you go to a business, to a store, or you're trying to buy something, and that store is not ADA compliant, and you're injured because of a lack of ADA compliance, then there could be some responsibility there against the store. Likewise, if there is a hazard, and you couldn't have readily identified that hazard. And when I say hazard, what I mean is water. A puddle of water on the ground is a good one. Or the store may have left something for you to trip over or something along those lines, then the store owner could be responsible because you are providing a benefit to the store, and they owe you a responsibility to keep their store in a reasonably safe condition. If you're disabled and you require ADA compliance, that can bring in a whole nother set of issues that could find the store responsible for your injuries.
We've got callers waiting. We've got Bob on the line with a question from Harvest. Hi, Bob. Thanks for calling. What's your question tonight?
You want to record that?
Hey, Bob, are you with us? What's your question tonight? Thanks for calling.
Yes, ma'am. I've got my wife was involved in an accident a couple years ago.
Okay.
And it's the attorney that represents the people that are suing her want her to sign. She didn't have any insurance at the time. It had lapsed on us, and they want her to sign something stating that she didn't have any insurance so they could go after, I guess, his uninsured motors. Is there any liability or any trouble she could get into for doing that?
Good question.
Well, the first things first is that if you don't have insurance and you actually, your wife caused the wreck, then she could have some responsibility for that wreck. I mean, just because you don't have insurance doesn't mean that you don't have a responsibility. So the person that was the victim in this situation, they would have a claim against your wife. They could bring an action in court. If it's not already in court, file a lawsuit in the district court or the circuit court, or they could try to resolve the issue without having to go take that legal step of filing a lawsuit. If you're asked to sign something, though, if your wife and what that is that when your wife doesn't have any insurance, then the person that did have insurance may have what's called uninsured motorist coverage, which will literally step into the shoes of your wife and pay for the person that your wife injured or her property damage, his or her property damage, up to what the injuries and what the property damage would be worth. And in order to be able to take advantage of an uninsured motorist policy, you as the uninsured motorist have to prove that the person that caused the injury did not have insurance. So I suspect that that's why her lawyer is trying to get you to sign a document that says you didn't have insurance at that point in time to go ahead and have the proof that is necessary. You know, I always say before you sign anything, you ought to have a lawyer take a look at it to make sure what you're signing is going to be okay. You're not going to have some responsibilities down the road. I don't know what document that they're requesting you to sign, but I would certainly have a lawyer read over it and make sure that there's no sort of hidden agenda and there's going to be no repercussions if you do sign it. A lot of times those types of documents are signed. If you sign this, we're not going to bring an action against you. So it functions as a settlement. It could be to her benefit, but I would certainly have a lawyer take a look at it.
I think he was also saying that accident happened a couple of years ago, so
Yeah.
they might have run out of time on that,
Yeah.
right?
2 years in the state of Alabama. You got a time limit. You have to file an action in a court of law or settle a case within 2 years of you being injured. 1 year in Tennessee,
Okay.
but 2 years in the state of Alabama.
We got a caller calling in. Liz had called in about borrowing a vehicle. She says she's visiting from out of state. She's borrowing a vehicle from family members while she's here. If she has an accident, is her insurance back in her home state on the line, or is the borrowed vehicle's owner on the line?
Could be both. If it depends upon the severity of the injury. So whenever you are borrowing someone's car with their permission, the legal term for that is a permissive user. And that's allowed under Alabama law in most situations with most insurance policies. Sometimes policies of insurance will specifically exclude permissive users. So that's something that you would need to look at the automobile insurance policy. But most of the time they do apply. And so if you get in a wreck and you're borrowing someone's vehicle with their permission, the person's vehicle who you borrowed will have the primary insurance coverage. So that would cover you in the event that you cause a wreck, that you run a red light, you run a stop sign, or you change lanes and don't see the other person in the lane and cause a wreck and, God forbid, injuries. If you cause serious injuries that are worth more than what the person's car you borrowed has insurance to cover, then your own insurance policy on your own vehicle in whatever state that you reside in may provide secondary coverage. And so that's something you would need to look into in the event that that worst case scenario happens.
Okay. Thanks, Liz. We're going to take a break. Be right back answering more of your questions all about summertime injuries. Stay with us.
watching WAAY 31 Law Call. Your rights, your calls, live. Presented by the Tennessee Valley's award-winning personal injury and wrongful death law firm, Timberlake, League & Brooks. Featuring the knowledge and experience of Attorney Michael Timberlake, Attorney Will League, Attorney Heath Brooks, Attorney William Maservi. And hosted by broadcaster and family law attorney Sharon Doviet. This is WAAY 31 Law Call.
Welcome back to 31 Law Call. I'm Sharon Doviet. Tonight we're taking your calls and questions about injuries, particularly summertime injuries. You might have questions about pool parties or bicyclists on the road.
Right.
Calling your questions. Heath Brooks is here from Timberlake, League & Brooks. And we were talking earlier about bicyclists on the road.
Yeah.
There are a lot of bicyclists out right now. And as somebody who does personal injury cases, are you very more cautious, you think, than the average person around bicyclists and hobbyists like that?
I'll tell you, I'm cautious when driving a car because of the work that I do anyway. But, you know, Bankhead Parkway, we all know Bankhead Parkway is rough for bicyclists, it's rough for motorists. We have to, as motorists, we have a responsibility to share the road with bicyclists, and bicyclists have a responsibility to follow the rules of the road as if they were a motor vehicle for the most part. But going around those curves, you know, you got to be extra careful, particularly in the summertime. There's a lot of bicyclists out. And as a bicyclist, you got to be extra careful because there's a lot of cars. Kids are out of school, you know, and out and about during the day. So it can be a pretty significant time. We see a lot of bicycle accidents, you know, occurring most of the time. You know, you hear the same old story. I didn't see them. You know, is something that we hear often. Fortunately, there's an organization that's trying to get bicyclists, maybe to get them a little bit off of the road.
Yeah.
So.
Just take your time. If you can't get around them safely,
That's right.
You can't get around them. We got in an email question from Sean. Sean says, my cousin was bruised up when he was hit by a boat while he was swimming around the dock. He was told that the driver of the boat was not the boat's owner. Does that matter?
It could. I mean, as we said earlier with another caller, you know, if the person who is driving the boat did not have permission to drive the boat, there may not be any insurance on that boat. And there may not be any insurance on the boat anyway. If you're not required, you know, you got to make sure that there was actually insurance to cover liability on that boat. And if there is insurance, they may exclude other boat operators. So it could certainly matter if the boat is not your boat. What you hope is that, one, there is a policy of insurance on that boat, and two, that it covers the person that was actually operating the boat. And your claim would be against the person that was operating the boat. But yes, it could matter. You'd have to look at the insurance policy.
We got a text message in. Somebody's asking, what should I do if I tripped and fell at a public park due to an uneven pavement and on the designated walking track? So when they're building something, if they're not maintaining it and it's a public facility, what do you do about that?
You know, it's a different animal. We talked a little bit about this earlier. It's a different animal when you're dealing with a public entity like a county or a city government. There are some specific requirements when you're dealing with a city or a county. The first thing that needs to be addressed is that there is a different time limit. If this public park is owned by a city, then you as the person who was injured have a responsibility to file a notice of claim with the city within 6 months of your injury, or you will not be able to pursue your case. In Huntsville, what you do is you go down to City Hall and there is a form that you can fill out and then you can provide that notice of claim. If it is against a county government, then you have a 1-year requirement to file a notice of claim with the county. So once you get past that time, the time limit issue, the notices of claim, 6 months for the city, 12 months for a county, then how is a city responsible or a county responsible? Well, it's a little different ballgame. The county and the cities both have a responsibility to upkeep their parks and to provide a reasonably safe park or sidewalk, and to warn of dangers that they knew about or they should have known about. You know, we've got a case now where we're addressing this against a municipality in the state of Alabama where there was an uneven sidewalk. And one of the big issues is, did the city know that the sidewalk was uneven? So there are things that have to be proven when you bring an action against a city. Did they have knowledge of this uneven tract? How long was it there? What caused it to be uneven? But in a situation like this, you definitely could have a claim against the city or the county. That would be something you would really want to bring to the attention of an attorney. These are very serious cases, very litigation heavy cases that can take a long time to work through, and they require a lawyer to take a look at.
People
Really
can
do.
get hurt more seriously than you think, just uneven sidewalks. Folks out running.
You know, the ground comes up fast and it's hard. And if you fall on concrete, we're talking head injuries, broken bones, concussions that can persist for long periods of time. You know, it's caused, we've seen really, really, really serious accidents involving sidewalks.
Just plain old sidewalks.
Uneven sidewalks.
Yeah.
Because who's looking when you're walking down a sidewalk? You expect the sidewalk to be even.
Yeah.
And then you've got this ledge, and you trip and you fall on it and your face hits the concrete, and it's a problem.
We got this email question from Kirby. Kirby says, if your dog bites someone, are you responsible for all their medical bills? Your dog bites. Does that make you responsible for everything?
Generally speaking, the answer to that is yes. If you have the dog, and this is particularly true if your dog has bitten someone before. Now, if you're a trespasser on somebody's property and the dog bites you, then that's not going to be the owner of the dog's responsibility. But specifically, if the dog is off of your property and it bites someone, then you're most likely going to be responsible for the medical bills that resulted from that dog bite. Alabama law does allow a single get out of jail free for a dog bite in certain situations, but if your dog is particularly off leash on somebody else's property and it bites them, you're most likely going to be responsible for the medical bills.
Let's talk a little bit about things that are attractive to kids in the neighborhood.
Yeah.
Pools, trampolines, things like that. If kids come on your property, you didn't invite them over there, but they're on your property and they get hurt or drown in your pool or get hurt on your trampoline, you didn't invite them there.
Yeah.
Are you liable for that?
You know, we've had horror stories involving pools. And during the summertime, this is something that I tell everyone who will listen. Keep a 4-foot locking fence around your pool. Not only is it the safest thing to do, but it is also the law in the state of Alabama, in Madison County, and in the city of Huntsville and the city of Madison. And the reason for that is because kids, and there's this old legal theory, the legal term is coming to a nuisance. And there's this old legal theory that if you have something that is fun for kids over on your property and they come and they get hurt, then you could potentially be responsible for the children getting hurt. But take the pool a little further, because what happens is a 2 or a 3-year-old, 20 seconds, 10 seconds, 5 seconds is all that it takes. This child gets away from their parents, wanders to a pool. There's no fence up, the boards are rotting, the gate's open. They go into a pool and then they drowned. And I unfortunately have had multiple cases where that specific situation has occurred, when there was no fence around the pool, no locking gates. Child gets away and drowned in the pool, and it is a devastating situation, and easily preventable. Make sure you have a 4-foot fence. Make sure you have locking gates around the pool. Avoid the disaster.
Let's talk a little bit about beaches, water parks, kind of thing. If you take your kids, you drop your kids off at the water park, and you think they're watching and they're going to be responsible for your kids, don't they have to have trained people? They got to have lifeguards. They got to have all that. But things happen.
Right. Yeah, sure. I mean, you know, when you go to a water park, same rules apply. You have to keep your water park in a reasonably safe condition and warn the folks that are there of hazards that they knew about, should have known about, or that this water park created. So that's the first level. The second level is that you are dealing with children that are swimming in pools, tidal pools and things of that nature. So you have a responsibility to provide safety, to provide lifeguards that are trained and qualified to ensure that those children don't drown. And if they do, as an organization, you could be responsible for the consequences. And also you have a responsibility as a water park to upkeep your equipment. We've dealt with injuries that have occurred on water slides where the slide has become separated and caused an injury.
Ooh.
So there are injuries that occur at water parks, there are injuries that occur at lakes, there are injuries that occur in the ocean. Most of the time, particularly in the drowning in a water park, there's a responsibility to have a lifeguard.
Okay.
Sure is.
We're going to take a break, be right back answering more of your questions about summertime injuries. Stay with us. If you didn't get your question, get in Tim Huntsville, 5770 or 800-804-2502. They are personal injury attorneys. So that's everything from the things we've been talking about, fireworks injuries, but also medical malpractice and regular old car accidents. Also check out the website law-injury.com. And if you like them on Facebook, you can learn more about the law that way.
And Sharon does family law, that's divorces and child custody. She can be reached at 256-539-7337 or www.sharonfamilylaw.com.
Thank you. Let's talk a little bit kids and signing releases. All these trampoline parks and water parks, they a lot of times will have the family sign a release. Kids signing releases?
A kid can't sign their own release.
Okay.
And so what these parks think is going to happen is the parents are going to sign the release for the children, and that's going to hold up in a court. It doesn't hold up in a court. Kids can't form contracts, and if a child is injured in one of these parks, regardless of the release that the parents sign, the park could be responsible.
To what age? 19 in Alabama?
19.
19
Saves
in
majority.
Alabama. Thanks for your questions. We'll see you next week.
Have a great night.